Good morning, ladies and gentlemen. My name is Howard Jarvis, and today, on behalf of the Knoxville Bar Association and its Legal History Project, we are here in the offices of Woolf, McLean, Bright, Allen, and Carpenter to discuss with Lou Woolf his career, which spanned over 50 years of practicing law. Good morning, Mr. Woolf. How are you?
Howard, I'm fine.
Very good. Lou, we do appreciate you being here today, and we do know that you had a career that began in 1961 and spanned 51 years of practicing law in Knox County, East Tennessee, across the state of Tennessee, and quite frankly, expanded to include most of the states in the United States. But we want to talk to you a little bit about what it was like to begin practicing law in 1961 and how that era shaped your career as it went forward.
I got out of law school at the University of Tennessee in January of 1961. And I got a job with the American Law Division, which is a section of the Library of Congress in Washington, D.C. That caters to Congress and their subcommittees and does all of their legal research. And so I went up to Washington in January of 1961 at the time when John Kennedy was president, Robert Kennedy was Attorney General, John Glenn had just gone up as our first astronaut. And I was up there for about 6 months and came back to Knoxville and went into practice with Baker, Young and Baker, which was a small law firm. I was their sixth person when I became associated with them. And at that time, from a litigation standpoint, Knoxville was the hub of litigation, quite different than it is today. Back in those days, and you may remember, Howard, because you tried lawsuits when you started practicing law in the same environment, the three circuit courts used to set 3 cases a day. The federal court used to set 3 cases a day. So here in Knoxville, we had 12 trial cases set every single day, 5 days a week, 52 weeks a year. And we tried cases either in the circuit court or federal court or in the general sessions court of Knox County 2-3 times a week. I would say that back in those days, and for my first 10 years of practice, in which I did what I call bulk defense trial work representing insurance companies, we probably tried 2 or 3 cases a week, every week, 50 weeks a year.
Lou, let me ask you this. When you're talking about trying cases, you're talking about, in that era, learning how to pick a jury, open a lawsuit, put your witnesses on, cross expert witnesses, and close a case. And I bet most of the time it was done in about a day.
Okay. You're absolutely right. During that first 10 years, we had automobile accidents, slip and fall cases, workman's comp cases, railroad crossing accident cases, dog bite cases, every kind of case you could possibly think about. And you had to prepare it yourself from beginning to end. You had to do your own research. You had to write your own briefs. You had to prepare your own motions. And I used to do all of that in longhand because I hated the dictaphone that we used to have available in those days. So I would write out my briefs and write out my motions, and my secretary would type it up. The thing that you learned was you had to start by interviewing witnesses, because in those days you would talk to the police officer You didn't take his deposition. You would talk to a witness. You didn't have to take their deposition. The only depositions you took might be of the plaintiff, because I did nothing but defense work. So I take the deposition of the plaintiff's doctor, and the plaintiff's expert if an expert was required. If it was an automobile accident case, as an example, I would go out to the scene of the accident. I'd make measurements of skid marks. I would take photographs with a Polaroid camera. I hope everybody who's watching this knows what a Polaroid camera was. Those were the things that we used in those days to prepare lawsuits. But the most important thing of all in the preparation of a lawsuit was to kind of figure out what you were going to tell the jury, what your theme of the lawsuit was, so that when you went to court, you began to learn how to communicate with the jury. You learned when to object and when not to object. I'll give you an example. The first day you have a trial, you want to object to everything. The second day you have a trial, you want to only object to half of the things. The third or fourth or fifth time you're in trial, you begin to understand that you don't have to object because it's a leading question. You don't have to object because it may be inadmissible. You pick your spots.
Lou, you mentioned something that I know that my late Uncle Howard from the old days of, practicing law in Knoxville told me, the first Howard Jarvis, that preparation is roughly 90% of being able to win a lawsuit, and 10% is what you do with your preparation in the courtroom. And what you're talking about really is being prepared, because you could go any way you needed to go if you were prepared.
Howard, Mr. Jarvis, was absolutely correct. Preparation is everything.
Now, something else that you have taught those of us who have had the privilege of practicing law with you for, quite frankly, the majority of your time as a practicing attorney, was that everything you do should be for the four corners of the courtroom. And it also sounds like that's exactly what you're talking with us about today.
From the beginning of my trial practice, the only thing I have ever thought of is the four corners of that courtroom. Everything I did in the preparation of the case was in consideration of those four corners of the courtroom. I never worried about the client. I never worried about what the client thought. In all seriousness, I worried about how I was going to present the case in front of a jury, or in front of a court, or in front of both, in order to be able to successfully defend that case. You show me an attorney that prepares better than the other side of a lawsuit, and I'll show you an attorney that has a greater chance of winning every single solitary time. And the key to preparation and the key to the presentation of a lawsuit in front of a jury is two things. Excuse me. One, keep it simple, stupid. And I used to have written on a blackboard in my office, KISS, just to remind me that I'm the guy that's stupid, and I need to keep it simple in making a presentation to the jury. And the second most important part in the preparation and trial of a case is to develop a theme of what your lawsuit is. Because if you have a theme, you can not only present it to the lawsuit, present it to the jury multiple times during the course of a trial, but if you get in any trouble, as we all do, no matter how well you prepare a case for trial, unexpected things are going to occur. What's the expression? Things will go south in a heartbeat. If you're not prepared, but they'll still go south every once in a while, the more you're prepared. And if you have a theme that you can fall back on, it can overcome the difficult times that you have during the course of trial.
Lou, as I mentioned, those of us who are members of Woolf McLean, we were with you at Baker, Warrington, Crawley, Stansbury, and Woolf. And we've had the privilege of being with you for over 30 years in your practice of 50 years. But your practice is somewhat divided into distinct periods of time. You have discussed with us learning how to try a lawsuit by being able to go to court at least once or twice a week to try a jury trial back in that era of the 60s when we had a lot of jury trials, whether it be state or federal court. But you eventually began to develop and expand your practice because of what you had learned how to do into other areas. And I think one of the areas to which you expanded your practice, and you ended up trying significant litigation in the East Tennessee area, is in the area of products liability.
You're right. I was extremely fortunate. The first 10 years of my practice, I did bulk defense work, as we've discussed. The second 10 years, I did products liability work. Then the next 10 years, I did asbestos work. In my last 20 some odd years, I did toxic tort work, primarily representing various companies in the petrochemical industry.
Because we are looking at legal history in our area, I'd like you to discuss with us some of the significant cases that you tried, most of which you won, but sometimes we don't win them all. But in particular, there was a products liability case tried in federal court entitled Lee versus Ford in the late 1970s. And would you tell us something about that?
I remember it well. Joe N. Lee. Mr. Lee was a driver education teacher for one of the county school systems. And one snowy morning, while driving a 1974 Ford LTD, I remember, he skidded on a bridge and went backwards. So the rear of his car was going forward at about 40 miles an hour. And coming across the other side of the bridge was a car that was going about 40 miles an hour. And they had a head-on collision between the rear of Mr. Lee's car and the front of the other car. And the closing speed of the two vehicles approached 80 miles an hour. Well, in the Ford LTD at that time, the gas tank was located in the trunk of the car. The bottom of the trunk of the car was the top of the gas tank. And so when those two cars collided, the gas tank ruptured. And for some reason, the air-gas ratio was just right that when they collided, the metal on metal created a spark, ignited the gas in the air, and a fire occurred. And the fire went inside the car and burnt Mr. Lee tremendously. He had third or fourth degree burns over most of his body. He was treated in the Cincinnati hospital that specialized in burns, recovered, and filed his lawsuit against Ford Motor Company, alleging that the vehicle was not crashworthy because the design of the vehicle was defective in that the gas tank was located in a place where in a rear-end collision the gas tank could rupture and the driver or passengers could be burned. About a year before this case was tried, Ford had a case in California involving the Pinto. and the Pinto's gas tank was in the rear of the car. There was a rear-end collision in that case. The gas tank ruptured. Many of the occupants of the vehicle were severely burned in the post-crash fire. They tried that case for 9 months in California, and there was a verdict of $124 million. At that time, I think it was the largest verdict in a personal injury case.
Correctly, it was a significant punitive damage verdict because
Included.
of documents.
Yes, included. The first case that was tried after that Pinto case was the Joanne Lee case involving the 1974 Ford LTD here in the federal court in Knoxville.
Well, and one of the interesting things about that is you mentioned that Grimshaw, back in that same era, took 9 months to try. I don't think that Judge Robert Love Taylor gave you 9 months to try Lee versus Ford, did he?
Lee versus Ford was tried from beginning to end, from picking the jury to the verdict of the jury in 5 days. We started on Monday morning at 9 o'clock and we finished at 5 o'clock on Friday evening. And the same experts who testified in Grimshaw for the plaintiff testified for the plaintiff in Joanne Lee.
They just weren't allowed to testify quite as long with Judge Taylor on the bench, were they?
If anybody knew Judge Taylor was, what's your name, what do you know, sit down. But the case, the significance of the case was obvious. Ford Motor Company was scared stiff because it was one thing to lose the Pinto case. It would be quite another to lose a case involving other model cars that had the gas tank in the rear of the car. So we had to come up with a theme as to how to win this lawsuit, because we weren't going to win the damages. Any trial lawyer worth his salt knew right off the bat that plaintiff's attorney, by the way, was Sid Gilreath, who did a marvelous job with regard to damages. There was no way to overcome the horrendous damages that Mr. Lee had. And to boot, he was a super nice guy and made a tremendous witness on the witness stand. So what we did is we thought about how could we win this lawsuit? And in opening statement to the jury, I said to the jury, ladies and gentlemen, I will never forget this. This was how many years ago?
1978 or so.
Yeah, you were talking 30, 40 years ago. I said, ladies and gentlemen of the jury, Ford Motor Company could put that gas tank anywhere they want to. If they wanted to avoid the tank being affected in a rear-end collision, they could put it in the front of the car. If they wanted to avoid it being affected in a rear-end collision, in a front-end collision, they could put it in the rear of the car. If they wanted to avoid it being affected in a side collision, they could put it in the side of the car. I said, in fact, the best place to put it would be halfway between the front and the rear and halfway between the right and the left side, right in the console of the car. So that when you put your hand on the car, on the console, you'd be putting it on the gas tank. And of course, if you lit a cigarette, we'd all be in trouble. So what Ford did is they determined that the best place, not the only place, but the best place to put the gas tank would be in the rear of the car, so that in an impact in a rear-end collision, if the gas tank ruptured, which was a rare occasion, the gasoline would go to the ground while the car went forward. Unfortunately, Mr. Lee's car spun out of control and went backwards, so that in effect you had a head-on collision with the rear of Mr. Lee's vehicle where the gas tank was located. So that while we could put the gas tank anywhere that we chose to, we actually chose to put it where we thought it would do the least damage. And to give you an example, I told the jury, In the Model T or Model A Ford back in the 30s, the gas tank was located in the glove compartment of the vehicle, where the glove compartment of the vehicle is. And so we suggested to the jury that the location of the gas tank was a reasonably safe location. Not the only location, but was a reasonably safe location, and therefore the location of the gas tank was not a defective design.
Lou, in being able to win a lawsuit of that nature and talking about the theme you presented to the jury about deciding on what was a good location for the gas tank, is that where, once again, the preparation and the thinking before you ever get into a courtroom to try a lawsuit comes into play?
I had one of the members of the firm, Roger Kessley, try that lawsuit with me, and we prepared that case for a year. Remember, back in the old days doing bulk defense work, you could prepare a case in a heartbeat because all of the cases were tried in a half a day. In fact, a wrongful death case back in the early days was tried in a week. In a day. Protracted trials were unheard of. We went to Ford Motor Company and got all of their documents that had been introduced in the Grimshaw case. And we got one of the vice presidents of Ford to sit down with us and go through each and every one of those documents so we would be able to cross-examine the plaintiff's experts from strength, not from weakness. The vice president was too busy during the day, and he only agreed, this is the truth, to meet with us at night. So every night for a week, we met with him, and he went over each of the documents because he was instrumental in the preparation of those documents. Excuse me a sec. And at the end of that week, we had an idea as to how to try the lawsuit. And so we prepared our witnesses accordingly. We prepared the experts accordingly, and we went and presented that theme to the jury. The one interesting fact is that the plaintiff had a film called Crash and Burn, in which some organization had put dummies in a car and then would rupture the gas tank, light a match to the gas, cause an explosion, and they would film the fire as it burnt the dummies. And you could see the plastic melting, etc., etc.
And this, of course, I'm sure got shown to the jury.
When Mr. Gilreath tried to introduce it to the jury, he had previously shown crash tests involving the 1974 model vehicle. So when he went to introduce this devastating, extraordinarily prejudiced film, I stood up and said, Your Honor, I object. This is kind of repetitious. He's already shown crash tests of the 1974 vehicle, and that's what's involved in this case, in this film, as well as some other vehicles. He says, well, we've seen enough of the 1974 vehicle, and we don't need to see any other vehicles because they're not involved in this case. Objection sustained.
That's called lawyering, isn't it, Lou?
It's called lawyering with a great deal of luck. And I took the film and I gave it to Roger Kessley and I said, sit on this thing. Don't you ever let it out of your sight. And the funny story is that at the end of the trial, when the evidence was being sent to the jury, one of the pieces of evidence that was listed was this film. And I said, Roger, stick that thing under your seat and sit on it. That ain't never going to go to the jury. And it never did. Nobody raised any question, and knock on wood, the jury never saw it.
Lou, I want to turn your attention just quickly to two more significant products liability cases.
Before you do,
but just like always, you want to say something else. Go ahead, Lou.
When the jury came in, I got to tell you this. I think the people who look at this may enjoy this. The alternate juries were excused, and one of the ladies came out and went over to the Ford engineer and said, "I'm selling my Ford. I'm buying a Volkswagen. I think it's the most dangerous car on the market." And the jury was out for another 4 hours, during which, you know, you can imagine how I felt. When the jury came back in, the foreman stood up and said, "Your Honor, we would like to read you what we have written." And they had written out on a piece of paper as follows: "We find the location of the gas tank in the 1974 Ford Galaxy to be a reasonably safe location," and dismissed the case.
Lou, I want to ask you about two more products cases, and then I want to turn to a second area of your practice as years have gone by. And I want you to talk for just a couple of minutes about an incident that happened in Loudoun County Circuit Court when you were defending Chrysler. And what I really would like you to discuss with us is the very fact that preparation, once again, shall we say, allowed you to pull yourself out of the fire that you put yourself into in that case. So would you tell us about that?
Howard, that was a very simple case, but proves the point that preparation and themes are critical to a successful defense of a case. A young man was driving a Chrysler, and he rear-ended the car in front of him. And he claimed that the reason he rear-ended it is because the brakes failed due to a defect in the braking system. And he had a Polaroid photograph that allegedly was taken right after the accident that showed the brake lining, not the brake lining, the brake line, okay, broken and hanging down, that you could see when you looked at the wheel of the car. And he showed that to the jury, and his expert testified that that was evidence that there was a defect in the braking system, because a brake line is not supposed to look like that or or break away from the wheel of the car. And so I got up to cross-examine the plaintiff's expert, and what I had done is I had taken the wheel, the hub of a wheel of a vehicle, and I brought it into the courtroom with the brake lining intact, with the brake line intact. And I put it up on a part of where the witness was seated, and I was strumming the brake lining in order to show the jury that you couldn't take it loose. And all of a sudden, it popped. And it hung down just like in the picture that the plaintiff had showed the jury. And like the photographer and you are grinning, the plaintiff's expert started to laugh. And the jury started to laugh. And without batting an eyelash, and don't ask me how I thought of this, without batting an eyelash, I looked at the witness and I said, "Why are you laughing? I told you that the only way this brake line could become loose is if somebody tampered with it." And I put the hub down and I turned around and I walked away and sat down at the counsel's table, and my right leg started to shake dramatically because it finally dawned on me what had occurred. The jury stopped laughing, and I never asked the witness another question. When the jury went out, they were out for less than an hour and came back in and dismissed the case. Now, the reason I was able to come up with that response was not because of how, quote, good, unquote, I might be. That's not true. It was because of the preparation that took place and the fact that I had a theme for the lawsuit that I had practiced and practiced and practiced before the trial, so that when that brake line broke, not broke, but popped loose, the first thing that came into my mind was the theme of the case. And I think that dramatizes to a young lawyer how important it is, because obviously I got in trouble, as you indicated. But by having the theme of the lawsuit and by using that, we were able to get a defense verdict.
Lou, another case that stands out to those of us who have known you for these many years was a piece of litigation you tried in federal court in Greenville, back also in the early to mid 80s, if memory serves me correctly, involving the Ford park to reverse allegations of defect. And I want to set the stage for you by saying that you knew you needed, to keep your witnesses off the stand if possible. But what you did in that case, and in its own way, the backhanded compliments you later on received from the company. But if you would tell us about that Ford park to reverse case in Greenville.
Okay. Back in those days, the transmission, the shifting of the gears, was on the column of the vehicle. And it was called a Prindle, park, reverse, neutral, drive, and low. And it had an arrow, so that when you shifted the gear shift, the arrow would go from reverse to neutral to drive to low, or all the way back up to park, and the arrow would be on whatever indicator you put the gear shift into. When you put it into park, okay, if it's designed properly, in the transmission itself, the wheels will lock up and the car won't go forward, whether the engine is on or whether the engine's off, whether the brake is on or the brake is off. In this particular case, an elderly woman was driving a Ford 150, and she parked it on a hill. Got out of the car, leaving the engine running, okay, and no brake on. And the car went backwards and ran over her legs. And she filed a lawsuit against Ford Motor Company alleging that she had put the gear shift in park and it had jumped out of park into reverse while the engine was running, causing the vehicle to go backwards. At that time, there was a huge investigation going on by NHTSA with regard to automobiles that would, quote, jump out of park.
And NHTSA's National Institute Traffic Safety Administration, I believe.
That's right. And the reason I didn't say that is because I have a hard time remembering what those acronyms mean.
Yeah, I tried lawsuits with you. I know that. So,
but in any event, in the preparation of that case for trial, by that time I had been doing a lot of Ford Motor Company work, stemming from the post-crash fire case that we had fortunately won and we talked about earlier. And I was on a national committee with 5 other lawyers who were doing Ford Motor Company cases in different parts of the country. And one of those cases were the park to reverse cases. And so in preparation of that case for trial, I had 5 experts. We had the vehicle examined. We had a mock-up of the transmission. We had a mock-up of the Prindle. We had, at the time of trial, a van loaded with demonstrative evidence, and had the 5 experts, 2 from Ford and 3 from different parts of the country, in the witness room in the federal court in Greenville. When we started the case for trial, I asked the jury how many of you would get out of a car with the engine running and your brakes not on, parked on a hill, without looking to make sure you had put the indicator in the park position. And nobody raised their hand. When the trial occurred and the plaintiff got on the hand, now mind you, this is a big-time products liability case. I took out 3 Polaroids. Remember, we had talked about taking Polaroids?
I think you still use
back in the old days.
Camera, but
3 Polaroids. And I showed her a Polaroid of the Prindle of the gear shift in drive. No, I'm sorry. Yeah, in drive. And I said, would you have gotten out of the car if it was in drive? And she said no. And I showed her one in reverse. And I said, would you have gotten out of the vehicle if it was in reverse? And she said no. Then I showed her one in park. And I said, is that where it was when you got out of the vehicle? And she said yes. And I said, how do you know? And she said, because I looked. And I said, in other words, before you got out of the car, you did what a normal person would do, a safe person would do. You looked to see that the indicator, that the arrow was in park. And she said, yes. And I said, thank you, and I sat down.
Now, Lou, at that point in time, plaintiff is close to resting her case.
That is correct.
And now the burden shifts to you with that testimony.
Hold on a second. The plaintiff's expert testifies. And I get up and I ask him the following questions. I said to him, you examined this vehicle. Yes, I did. Let me show you these 3 photographs. If the Prindle was in drive, could she have gotten out of the vehicle? And he said no. If it was in drive, as soon as she took a foot off the brake, it would have kept moving. I said, could it have been in reverse? He said no. She couldn't have gotten out of the vehicle in reverse because as soon as she took the foot off the brake, it would have gone in reverse. I said, could this accident have occurred if the indicator was in park as shown by this exhibit? And I showed him the photograph that she had identified, that she had looked, and that's where the Prindle was. He said, absolutely not. I tested the vehicle. If the indicator was in park, the vehicle would never have moved back under any circumstances. And I sat down. Now comes plaintiff rests.
And now becomes decision time for Lou Woolf defending Ford Motor Company in Greenville, Tennessee.
Okay. I got up and I said, Your Honor, I move for a directed verdict. At the conclusion, I moved for preemptory instructions at the conclusion of the plaintiff's proof. And he said, on what grounds? And now is what becomes interesting. Back in the days when I did bulk defense work and we did automobile accidents, one of the key things was lookout. did you keep a proper lookout while you're driving a car? And one of the old cases that I had run into when I did my research at night, as we talked about, was a case called King versus Smythe, S-M-Y-T-H. Okay? It was a case involving an automobile that ran into, a horse and buggy ran into the side of a railroad car at a crossing and filed suit claiming that the railroad car shouldn't have been there. And the court held that the suit should be dismissed because when a person says they look, they are bound to see what's there to be seen. So if you say you look to see a stop sign, then you're charged with seeing it. If you look to see a railroad car, you're charged with seeing that it's there. You can't be heard as a matter of law to say I looked, but I did not see, unless there's something that was obstructing your view. So I made the argument to the court that when the plaintiff said she looked, then she was bound to see that it was not in park, because her expert had already testified that if it was in park, the vehicle would not have gone backwards. And Judge Marion, who was the magistrate, and both plaintiffs and I had agreed under the rules that the magistrate could try the lawsuit in place of the federal judge, said, I'm going to overrule your motion at this time. And we broke for lunch. And while we were at lunch, I said to Roger Kessley, I said, if it wasn't that Ford Motor Company was one of our most important clients, I'd rest. I wouldn't put on any further proof, because frankly, we've either won this lawsuit or not. And he said to me, you're not hired to worry about the firm. You're hired to give Ford Motor Company the best advice you can. And I remember saying to Roger, Roger, if you're a woman, I'd give you a kiss. And I went back to court and stood up and said, Your Honor, I rest. And now I renew my motion for preemptory instructions at the end of all the proof. And the plaintiff's attorney said, Your Honor, he's already made that motion. And the judge said, no, counsel, he made the motion at the end of your proof. Now he's making the motion at the end of all the proof. Excuse me. And I renewed the motion, went back to argue about you're bound to see what's there to be seen. And the judge said, I'm going to overrule your motion, and I'm going to give you each 15 minutes to close the case. And the plaintiff's attorney only had 15 minutes to talk about what he thought was his theory of the case. And I got up and I said to the jury, and again, how I remember this, I have no idea. I said, I want you to know that the plaintiff simply made a mistake. Okay? And the mind is a wonderful thing. It won't let you blame yourself for the serious injuries that you may cause. And she firmly believes in what she told you. But the truth of the matter is she made a simple mistake like we do every day of our lives. You leave the window open and it rains in. You leave the oven on if you have a gas oven. You leave it on. The pilot light, you leave it on. And luckily, nothing occurs. You leave the keys in the car and you lock it and the car's locked and you can't get back in the car. You trip. We all make simple mistakes, and that is exactly what the plaintiff did in this case. but the evidence shows there was really nothing wrong with the transmission. That is, the plaintiff's expert testified to. If you put it in park, it would have stayed there. And I sat down. I called Ford Motor Company to report what I had done. And they said, "You what? You didn't put on any proof?" And I said, "That's right, but I can't tell you anything else because the jury's coming in." And I hung up the phone. The jury was out less than 20 minutes. Major products liability lawsuit involving the C6 Ford transmission that was in millions of cars throughout the United States. And the jury, knock on wood, dismissed the case.
Lou, the ending to that was Ford Motor Company actually gave you a reward, but also told you it was a retired award.
Yeah, they
and
told
all
me,
we need to know is what's the name of,
the
award that you hold as the only trial lawyer in America.
The engineering department put together a little exhibit that had a round brass ball in it, and they called it the Brass Ball Award. When the in-house lawyer at Ford in charge of the transmission litigation gave it to me, he gave it to me with the admonition, if you ever do anything like that again, you'll be fired. But the truth of the matter is, the preparation of the case, the depositions that were talked, the sitting down and thinking about how to best present the case to the jury, and coming up with a theme that was simple. Remember we talked about earlier, keep it simple, stupid? What we did is we took a products liability case involving a defect in design of an automobile, and we applied an old rule that if you look, you're bound to see what's there to be seen, and made it apply in such a way that the jury could easily understand it, so that the jury then would have a simple theory upon which to dismiss the suit.
Lou, as you know, over the number of years with which we've had a relationship, I oftentimes have had to make an executive decision about how we were going to handle certain things. So what I want to now do is move on to two more cases which have significance for this area, and then I want to get some personal observations from you about what it has been like to have practiced law in Knoxville, Tennessee for more than half a century, and the individuals with whom you had the privilege to come in contact during that period of time. The first matter that I want you to describe for us is the fact that in this jurisdiction, the asbestos litigation got off to a big time start, and you actually participated with a number of very fine plaintiff and defense lawyers in a case called Daniels in federal court involving exposure to asbestos.
The first asbestos case that was tried in this country after a huge verdict in Texas against Ray Bestis Manhattan was tried in the circuit court of Knox County. And I forget the year, but Paul Gillenwater was the plaintiff's attorney.
A very good plaintiff's lawyer.
Okay. And one of the lawyers who was involved in the asbestos cases nationally, Ron Motley from Columbia, South Carolina, I think, came up here to watch the trial because, as I indicated, it was one of the first cases of its kind. The defendants were multiple companies, and unlike the automotive design products litigation or the toxic tort litigation, where petroleum companies would hire one lawyer, in the asbestos litigation, each company had their own law firm. So in Knoxville, we had Fred Cagle, who was an outstanding attorney at that time, Bob Campbell, who was an outstanding attorney and who recently retired, Bill Vines, I'm trying to think of all the attorneys, J.W. Baker, and a host of other attorneys that I can't think of.
That's the truth, because of the number of defendants, there were any number of very fine defense lawyers involved in trying that type of case.
And what we did was Bob Campbell, Bill Vines, Fred Cagle, and myself were given permission to take the lead for the preparation and trial of the case. And if I remember correctly, the plaintiff was a 31 or 32-year-old gentleman who played golf. And he was a scratch golfer. And he didn't have asbestosis. He didn't have lung cancer. He had markings on his chest that everybody testified caused no adverse health effect at all. And the reason Mr. Gillenwater chose that case is because he wanted to get a feel for how one of these cases was tried. And so he chose that case hoping he could get a verdict in a case where the plaintiff didn't have any severe injury. What we did, on the other hand, is took all of the different legal issues, and each of the lawyers took one issue and argued that and presented that in front of the jury. Like if there was a statute of limitations question, or if there was an issue with regard to causation, so each of us took a different issue, all towards the same theme of the lawsuit, that the plaintiff really had no injury for which he should recover any money. And we presented the case to the jury, and the jury dismissed the case. And after the verdict, we took the jury out to lunch and asked the jury how they felt about each of these individual legal issues in order to get feedback, because at that time there were maybe 100 asbestos cases here in Knoxville. As it turned out, as time progressed, there were tens of thousands of asbestos cases throughout the state of Tennessee that each of the law firms that represented these companies in Knoxville handled, not only in Knoxville, but in other counties throughout the state. But that verdict was a shock throughout the country, because the plaintiff's bar was gearing up for the asbestos litigation that thereafter became a matter of history.
Lou, the last 15 to 20 years of your active practice focused on the area we refer to as toxic torts, whether exposure to a certain chemical can cause a certain cancer, and if so, at what dose of exposure can that cancer result?
That's right.
You had the privilege here in Knoxville in federal court of trying a case called Kitts versus Exxon. And would you briefly describe that case for us?
Well, what was interesting is this was a case involving the chemical benzene. And it was alleged, excuse me, that benzene caused acute myelogenous leukemia, which is what the plaintiff's husband died of. He was a painter at Plastiline here in Knoxville, and he painted outdoor illuminated signs. And he was one of the guys that also mixed the paint. So he would take the paint and he would take a solvent like toluene that contained benzene, and he would dilute the paint, put it into a spray painter, and then spray in order to see that the liquid was sufficient enough to go through the spray paint. And so he was exposed to toluene on a regular basis, and therefore exposed to the benzene that was in the toluene. I received a phone call from Exxon and Ashland Chemical Company, who were the two companies that had sold Plastiline, the toluene that the plaintiff was exposed to. They asked me if I knew anything about benzene or anything about toluene, and I told them no. And they said, well, you do asbestos work, don't you? And I said, yes. You know what dose is all about? And I said, yes. They said, are you willing to learn? And I said, yes. And they said, well, we've checked with Ford Motor Company, and they tell us that you are a very, very fine trial attorney, and we'd like to hire you. So that's how I got hired.
And in that case, certainly there was a very fine lawyer on the other side in Bill Vines.
Absolutely.
One of the best lawyers in our community. And you did try that case to verdict. And I believe you, and obviously was in federal court.
Right.
You used some of the leading experts of the time in the area.
I did. The case became very, very significant from a national standpoint because it involved not only the toluene that he used in the workplace at Plastiline, but he also operated a mom and pop store in Kentucky in which he pumped gasoline. And gasoline contains trace amounts of benzene. So the case originated that it was the gasoline and the toluene in combination that caused his AML. And of course, Exxon was extraordinarily interested in the gasoline part of the case because, for obvious reasons. We tried the case, and again, it was in front of Judge Taylor, or I guess it was in front of Judge Hull. And I think we tried it in maybe a week and a half at the most. Bill Vines presented one of the strongest cases that I had ever seen previously. And although over the next 20 years I did this chemical work all over the country, he presented the strongest case that I've ever seen since. He was and is a very, very fine attorney. I used an expert from Harvard by the name of Dr. James Yondell, who had written a book on hematology entitled Blood. That was it. It was the leading textbook used in medical school throughout the country. And in it, he had a chapter on acute myelogenous leukemia, and he also had a section, believe it or not, on benzene. And so I went and visited Dr. Yondell, and he and I hit it off really, really well, and asked him if he'd come down to Knoxville to testify. I also had a hematologist from San Francisco by the name of Dr. Ralph Wallerstein, who in those days was in his 70s, and he agreed to come to Knoxville and testify. And what was interesting, as an aside, in cross-examining Dr. Wallerstein, Bill Vines asked him how much he charged. And I forget the hourly rate in those days, but he charged an exorbitant amount. And Bill said, well, how much is your total bill? And he told him, and he said, my gosh. He said, why do you charge so much? How do you do that? And Dr. Wallerstein, who I said was in his 70s, he said, you know, there ain't that many of us around who were back there in the beginning of when we learned about all these chemicals. And so I charge whatever I can get away with. And the jury burst out laughing. And Bill sat down and didn't ask him any more questions. Another interesting part of the case is Bill caught me by surprise in his cross-examination of Dr. Yondell. Apparently, Dr. Yondell had had a disagreement with the American Petroleum Institute. And Bill went into that disagreement and made Dr. Yondell look very badly. And in cross-examining Dr. Yondell, he attempted to make him look like he may have been fabricating his testimony. I did not anticipate that. But by that time, I had had a lot of years' experience in trying lawsuits, had prepared this case to the fullest extent, and I stood up and I said, Dr. Yondell, do you realize that plaintiff's attorney is trying to make you out a liar? And I sat down. And Dr. Yondell looked at the jury, and then he looked at the plaintiff and said to the plaintiff, if I thought for 1 second that your husband's death was caused or contributed by exposure to toluene, I would not be here. But I firmly believe that based upon my scientific knowledge and my research and my years of experience, that your husband's AML had nothing whatsoever to do with exposure to toluene in the workplace or to gasoline in the mom and pop operation. And there was silence in the courtroom. And I didn't interrupt that silence. I just didn't do anything. And finally, Judge Hull looked at Dr. Yondell and said, Dr. Yondell, we appreciate your coming. Thank you for your testimony, and you can now be excused.
And of course, it was a defense verdict.
And knock on wood, the jury dismissed the case.
Lou, we have been going for approximately an hour, and so we're moving toward the end. I do want to point out, for those that may watch this video, and hopefully there will be some that will take the time because of the experience you can share with all of us, that your practice, particularly from asbestos and toxic tort, and quite frankly for Ford Motor Company, literally took you into how many jurisdictions to try cases in your 51 years?
From what I understand, I have handled or tried cases in more than 37 jurisdictions.
Lou, some of us here, such as Hugh Bright, Kyle Carpenter, Denise Moretz, and myself, have had the opportunity to be with you in many of those jurisdictions at different times. I want to share with those that would watch this tape one of the best openings to a closing argument that I have ever had the privilege in 35 plus years of hearing from any lawyer anywhere. And ask you if you remember that long, hot summer we spent in Thibodaux, Louisiana.
Oh, yes.
In 1998. In the case. And do you recall that plaintiff's counsel, very, very good lawyer from Louisiana, who'd been Eddie Edwards' criminal defense lawyer on many occasions there, had really done a great job with the opening portion of his closing to set the stage. And it talked about fire and fury and hellfire and damnation to come. And what I want to say, because I know it verbatim, and then you can comment on it, is that you stood up, and oh, by the way, we should set the stage that our co-defendants folded like cheap accordions because they were concerned about something that had happened toward the close of our case in chief. So it was just you and me left. And you stood up and looked at that jury and simply said, ladies and gentlemen, I have three things to share with you. First, Mr. Jarvis and I would like to thank you for sending Peyton Manning to the University of Tennessee to play quarterback. Second, we think here in Thibodaux, Louisiana, you have the best pizza in the world. And third, it is hotter than hell here in the summertime.
So go out and bring your verdict back as quick as you can, regardless of who it's for.
They did, but you also went ahead and left me behind to take that verdict.
That's right. That's
but
exactly right.
You know, the inspiration for making that type of closing, which immediately diffused the emotion of a very outstanding closing by the plaintiff's counsel, is that also something that really, just by getting out there and doing it and knowing the four corners of the courtroom, lets you do that?
It's a result of how many years experience you have, and it's a result of being comfortable in front of a jury. Howard, I have told you this on many occasions. I firmly believe a trial is like opening night at a Broadway play. Everybody knows their lines. Everybody is prepared for opening night. No matter how much you prepare, certain unexpected things occur. But like opening night, what you as the lawyer want to do, excuse me, is make sure that that jury is comfortable with you and wants to know how you're going to handle things during the course of trial. As an example, when a bad document comes in a case on behalf of the plaintiff, you want the jury to sit back in their seats and say, let's see how Mr. Woolf is going to handle this. What you don't want the jury to do is sit back in their seat and say, oops, that's it, the defendant's toast. Turn him over, he's through. And it's extremely important to be able to instill that confidence in a jury as quickly as you can in the courtroom, so that when you get to a final argument, or to begin with, if I may digress, to me, your opening, your direct, your cross, and your closing is the same. You get to tell the jury your theme in opening. You get to tell the jury the theme in your cross-examination. You get to tell the jury your theme in direct, and you get to tell your jury the theme in closing. And by that time, what you want to convey to the jury is every time you step up, every time you stand up in a courtroom, the jury knows exactly what you're going to do, that they're ready to repeat the theme of the lawsuit. And so if you prepare cases for trial like that, if you consider the jury that you want to make them feel comfortable with you and what you say, then by that time, when you get to the final argument, you can pretty darn near say anything you want to, because the jury understands what your case is all about. And so I have been very fortunate, and that's a great example of what preparation, of keeping it simple, and having a good theme to prepare your cases for trial, what it results in. Do I have time to tell one quick little story?
Sure you do.
Okay.
Because you're going to take it anyway, because I've known you all these years.
I tried a case in front of Judge Jack Weinstein in the Federal District Court in Brooklyn, New York, in which he consolidated 64 wrongful death asbestos cases, all who have died of lung cancer, for trial at one time. Case took 6 months to trial. I was one of 3 attorneys. During the first part of the trial, within the first week, the plaintiff's attorney put on experts, and he led them all over the ballpark. He asked them nothing but leading questions. He would tell them what the answer was and then just simply say, is that correct? And I didn't say anything for the first few days, but then I decided for reasons that will become obvious, to make an objection. And so the next morning, when the plaintiff's attorney asked the first leading question of that expert, I stood up and I said, Your Honor, I have a point of information that I would like to discuss with the court. And Judge Weinstein said, What is it, Mr. Woolf? I said, well, the jury may not know that you are the author of the evidence books that every lawyer that is here in this courtroom has had to read in order to get their law license, called Weinstein on Evidence. And I said, last night I went out and bought one of your little narrow books called Leading and Narrative Questions. And there's a case here, and it's J.C. Weinstein. That's you, Jack Weinstein, Chief Judge of the Eastern District of New York. And he said, that's right. I said, as I read this case, it said if you put your questions in, if you put your case in by leading questions, that's grounds for a mistrial. And I said, if that's correct, and this was a leading question, then I object. If it wasn't a leading question, you just tell me and I'll sit down. The jury now, who I'm going to be in front of for 6 months, is hysterical. They're laughing. They're smiling for two reasons. They see the judge respects me, and they see I'm treating the judge with respect, and we're having a discussion. And so I sit down. And the judge says, Mr. Woolf, you're absolutely right. It is a leading question. But under rule so-and-such, and remember, this is the guy that wrote the book, under rule so-and-such, in a protracted trial, you can expedite the putting in of proof by leading questions. And I stood up and I said, Your Honor, and so help me, I did this. I said, Your Honor, does this mean I won or did this mean I lost? And Judge Weinstein says, it means it's time for you to sit down. And the jury burst out laughing.
Lou, on behalf of the Knoxville Bar Association, United States District Court Judge Pam Reeves, who was kind enough to ask us to do this, and those of us who have been your partners for so many years, thank you for your time today.
Thank you, Howard.